blood stain that matched with the victim blood, and for the motive behind for the commission of the offense has relied on the PW number 2 and PW number 11, where both has stated that uh, the victim has terminated uh, the accused from his employment twice during his manager period.
Where is his appeal petition? It's this one.
Appeal petition is at page 113, man. 113. And the English translation start from 121, my lord. If I may read, my lord. Sir, I beg you to kindly consider my issue before your honorable court and grant me my request. I was arrested on 29 March 2020 and was sent to district jail, Colosseum on 5th October 2023, convicted with a life sentence and a fine of rupees 30,000 in default. And I'm submitting the accusation made against me and my grievance to you against the order passed by the district and session judge of the fast track court Colosseum in my case. I do not deny that I am the main culprit in the misfortune that happened in this case. However, all the incidents of this case are accidental in nature. After the police apprehend me, I confess fully to PW number 31 SI Zoram Moyer Control Police Station. There are added and deleted statements in my said confession. My heart is deeply troubled on account of misfortune that occurred, and I still face problems physically and mentally till today. I deeply regret the incident and I really feel bad about it. I was under the impression that the police report my actual narration of how the incident occurred and on the event of 7 April 2020 when the police came to jail to take me to the Chief Judicial Magistrate. I was being questioned. I even expressed acceptance of my statement recorded by the police. My case IO SI Zoram Moy, who took me to the court, reassured me that all my statements were correctly recorded and that I would be jailed for a shorter period if I declare my acceptance of the records. I am, however, surprised that my confession was not recorded as actually declared by me. The actual incident happened in this manner, and this is how I narrated to the police. On 18 March 2020, we went to Aizawl and returned home. The same day, reaching at 7:30 p.m., I took a bed, and after eating dinner, I went to my friend Farah's residence to look at his new fighter. As my friend Farah was not at home, I decided to go back home. I had to walk past my old workplace named this filling station on my way home. I was walking back on foot, and as I was thirsty, I decided to get some water there without any hesitation. Our old supervisor named Mr. Dipandu Prasad was still awake. As his door was open, I entered to shake his hand. I told him how I went to my friend's place and how I decided to return home again as he was not at home. I asked him for some water during this time, and I thought of leaving immediately after drinking some water. He did not respond to some of my questions as he drinks alcohol regularly. I was under the impression that he was already drunk. I reached for the cup and poured some water on it. While I drank the water, Mr. Singh, in his drunken state, started cursing in Hindi language. He said that we Mizo are filthies as we eat the meat of dogs, and he threatened to kill me. As I kept the cup that I used to drink water, he immediately grabbed the cup and threw it back of my head. When we then started fighting unexpectedly, and he fell on the ground as I punched him. He had a knife when he got up from the ground. He tried to cut me with the knife, and I held his hand and we fought for the knife. Even after I took the knife from him, he jumped on me and continued to attack me. I do not know when the knife hit his body, as we were both busy fighting. I was shocked when he fell, and I was extremely scared and troubled. I was even able to think clearly. I poured the diesel that was in the room on me, and I tried to kill myself. I was too scared to even burn myself, and so I hastily left the room thereafter. I deeply regret the incident, and I really regret the misfortune happened. I am still suffering the consequences of this event emotionally and physically. I did not try to hit his body with the knife. I could not even see the knife hit his body, as I am blind on one eye. After being jailed, I have thought about the incident many times, and I feel the incident was unfortunate one. Had I not cut him with the knife, unfortunately, I realized that Mr. Singh would have anyhow killed me instead, as he fought to kill me with all his might. I sincerely regret the occurrence of such incidents, though I have clearly confessed to the police about the incident that took place. They have accused me to have pre-planned the killing of Mr. Singh owing to hatred. They have made up my confessional statement and even managed to not mention some of the actual truth revealed by me. I find this really difficult to understand. I am deeply hurt for being accused of planning to kill and intentionally murdering the deceased. Though I am responsible for the incidents, I did not do it by planning it or out of hatred, as we both fought physically, as I was able to grab the knife. I would like to reiterate that the accident took place as I am blind. The incident took place as a result of self-defense, and it happened by accident. I request you to kindly accept that this is how it happened. I now have lung problem, which leads to breathing difficulty that is being treated in jail. I have encountered many problems, as I am blind in one eye. My health condition is not good. My widow mother, who has been looking after me since my childhood, is now 71 years of age. She would visit me at an old age in jail with her frail health. I really feel bad that the unfortunate incident took place in my life, spoiling my entire future, and my family members are the ones who suffer most from it. I deeply regret the occurrence of the incident, and I am deeply hurt emotionally, considering my present problem and my rights. I request you to review and reconsider my case.
Was there any defense witness?
Yes, only one witness.
Let us see what is the version of the deed. Who is the defense witness?
The one he was traveling with on that day.
Traveling with on that day. Did he see the incident?
No, my lord.
Then,
There is no eyewitness.
so what is the relevance of this office evidence?
I don't think there is any relevancy, because he thought that the incident occurred at 7 p.m. my lord. That's why.
No, you see, the thing is that you have admitted. What does 313? Let us see 313.
Only 313, my lord. He simply denied the whole thing.
He denied.
Yes, my lord.
If he denied, why are you saying that he admitted?
Going through his memo of appeal, my lord. Yes, my lord, the conviction is based on circumstantial evidence. But I think each and every of the circumstances.
You see, the Supreme Court has said time and again that when in crimes of this nature, serious crimes,
Yes, my lord.
I'm not trying to put you down or anything, but a amicus or a legal aid counsel should be an experienced counsel, because this is involving the life of a convict,
Yes.
of an accused. So registry should have given a amicus with at least 10 years practice, with having 10 years practice. Otherwise, the way you started off, you basically convicted your own client. I think we'll send it back. But then, okay, why do you say that 304 part 2 should be made applicable here?
My lord, from the evidence on record of PW number 2 and 11 have stated there was a prior enmity between the victim and the
Why enmity?
Yes, my lord.
So that goes against you. That means there was a motive.
But my lord, there is some discrepancy regarding the PW number 4 has stated that the there was no prior enmity between the victim and the.
You cannot blow hot and cold. You have got to take one line. You cannot say this is black and then the next day say that this is white. It has to be the same. So was there enmity or not, as per the witness's testimony?
As per both the PW number 2 and 11, my lord, there was an enmity between the but
so if there was a motive, there was a previous enmity.
But my lord, if I may take you to the PW number 4, that is on page.
No, okay. Show us the injury. What is the? Let us see the medical report, the medical doctor's evidence.
The post-mortem report is started from 229.
229.
There are 3 incised wounds, ma'am.
3 incised.
Yes, ma'am.
And what did
page,
he?
Page 230, my lord. One is a cut throat injury in the form of deep gaping incised wound is present over.
No, you see the page 229, the last sentence. Blackening is present in all over the burnt areas,
and
multiple incised wounds are seen at the neck, face. And scalp.
Yes,
so, tell us, when is section 304 part 2 attracted? What is the requirement?
Under exception 1, my lord.
Exception 1 of? Exception 1 of 300?
Yes, my lord.
Under exception 1 of 300. Okay,
grave and sudden provocation, my lord.
Let us see.
If I may read, my lord.
Yes.
Yes, my lord. If I may read the exception one. When culpable homicide is not murder, culpable homicide is not murder if the offender wills the deprived of the power of self-control by grave and sudden provocation, causes the death of a person who gave provocation, or causes the death of any other person by mistake or accident. So, my lord, from the judicial confession of the appellant, my lord, he has stated that he went there to drink water, but mistakenly he has drink the water with the victim's special cup. So the victim cussed with Hindi by stating that you Mizos are filthy, and threw the cup at his back of the head, my lord. So
What does the law say regarding? What does the Supreme Court say with regarding to attracting 304 Part 2? Any citation?
no, my lord. I have one.
See, you're dealing with the life and liberty of a person. You have got to do your best for that person. Otherwise, that is why Supreme Court has said in many cases that for serious cases like murder, the amicus or the legal aid counsel should be an experienced counsel. Unfortunately, you're not experienced enough. It's very clear. You don't even have one citation, and you're
Yes, my lord. I have one citation
What is it?
regarding the interpretation of 300 section 300 IPC.
No, we're not on that. 304.
That's one.
Interpretation. What is there to interpret? There's nothing to interpret. What does it say? Your 300. What your citation? What does it say? And only you have got the citation. We don't have it. Para?
Paraten.
Yes.
Interpreting exception 1 to section 300 in KM Manavati versus State of Maharashtra. This court held that the conditions which have to be satisfied for the exception to be invoked are that deceased must have given provocation to the accused. The provocation must be grave. The provocation must be sudden. Power of self-control. The offender should have killed the deceased during the continuance of the deprivation of power of self-control, and the offender must have caused the death of the person who gave the provocation or the death of any other person by mistake or accident. For determining whether or not provocation has temporarily deprived the offender from the power of self-control, the test to be applied is that of reasonable man and not that of any unusual, excitable, and obnoxious individual. Further, it must be considered whether there was sufficient interval and time to allow the patient to cool. KM Manavantis plus succinctly observed, is there any standard of a reasonable man for the application of the doctrine of grave and sudden provocation? No abstract standard of reasonableness can be laid down. What a reasonable man will do in certain circumstances depend upon the custom, manner, way of life, traditional values, etc. In short, the cultural, social, and emotional background of the society to which an accused belong. In our vast country, there are social groups ranging from the lowest to the highest state of civilization. It is neither possible nor desirable to lay down any standard with precision. It is for the court to decide in each case having regards to relevant circumstances. It is not necessary in this case to ascertain whether a reasonable man placed in the position of the accused would have lost his self-control momentarily or even temporarily when his wife confessed to him or of her illicit intimacy with another, or we are satisfied on the evidence that the accused regained his self-control and killed Apuja with deliberate. My lord, in this case also, my lord, the appellant has tried to kill himself after he have committed such crime, my lord. He poured himself with some kerosene and tried to burn himself.
He burned the dead body also.
Yes, my lord. As he regained his thought, my lord. My lord, and my lord, by throwing the mug, my lord.
Huh?
Throwing
Throwing a mug, so what? Someone you see you see the retaliation
yes,
has to be equal. It's not that it's not that you go against somebody with a caterpillar and he runs over you with a tank. The provocation and the retaliation should be proportionate to each other. You see, supposing I come at you with a stick, you cannot shoot me with a double bore gun, with a double bore, because that is not proportionate. The reaction has to be proportionate.
yes,
He is throwing a mug at you.
yes, my lord.
You are not going to die with a mug being thrown at you. You hit him, you stabbed him with a knife.
No, I'm blind on one eye. Yeah, he must have thought that he physically hit him with throwing his mug, my lord.
You see, there are judgments of the Supreme Court which says that to see whether there was intention or not, and whether 304 Part 2 can be attracted, one will have to see the nature of injuries, the weapon used. Supposing you go against him with a mug, you throw a mug at him, and he comes charging at you with a knife. Is it fair? It's not proportional. I don't know where your case lies. As per your pleadings, 304 Part 2 doesn't appear to be attracted. And I don't know who told your client to submit such an appeal.
Yes, my lord, but the conviction was based on circumstantial evidence.
Correct. But then now he has admitted in his appeal petition.
Yes, ma'am.
And what is so wrong with the circumstantial evidence?
Each and every of the circumstances has not been proved beyond reasonable doubt, my lord.
No. You've got to think of what about Section 136 or 116 Evidence Act.
116.
What does it say?
106.
Yes. Give me Evidence Act. Is it 116 or 136?
I think, my lord, it's 106.
Ah. Yes.
Burden of proving facts.
106. 106.
Yes, my lord. Burden of proving facts, especially within knowledge.
Yes.
When any facts is especially within the knowledge of any person, the burden of proving the facts is upon him.
Yes. You see, why have this section been put here? The reason is that when something happens in the confines of a home, only those persons inside that house knows what is going on.
But my lord, this does not discharge the burden.
No, does not. But then you have got to explain also. What you see in your 313, you have denied everything that you were not present also.
Yes, ma'am.
In your appeal now you have admitted everything. Then in your appeal you have admitted that you were there. You are the one who did everything. Now, do we say that your appeal cannot be believed?
Yes. No, my lord. But one thing is that, my lord, the judicial confession is also corroborated with the PW number 6, my lord. If I may take you to the prosecution witness number 6, my lord, which is on page 137, my lord.
Yes.
If I may read, my lord.
Yes.
I know what the accused was produced before the court through VC. In the year 2019, I worked with Arlel Rinsanga, revival speaker, as one of his counselor. Rinsanga requested me and accused Suaitea Ananda to pay a visit.
Ananda, he's a what? He's a non-Mizo.
His father is non-Muslim. Pay to him a visit at Aizawl, and as such, 18/3/2020, we visited him and he gave me a stitched cloth for our uniform. On the same day at 5 p.m. we left Aizawl, and at around 7:30 p.m. we reached Bualpui. After reaching home, accused Waitea came to our house and asked me, Varsang Linatay Armin and Puiro. I refused, and I had to visit my cousin, serving army personnel, who is coming back on leave. Then he left our house, and soon after I also left our house. In between 8 to 8:20 p.m., while on my way, I saw the accused Waitea sitting inside the shop of his sister, and I went past him without exchanging words. When I reached my cousin's house, I stayed there for a while, and in between 9:30 p.m. to 10 p.m. I reached my home. While I was preparing to go to bed, my mother informed me about the burning Bualpui petrol filling station, and without delay I rushed toward the filling station. When I reached there, the fire was put out, and when I looked inside the burn house, I saw Pusinga lying dead on the floor. And cross-examination by the defense counsel.
Okay, look, let me read your appeal. Heng til seng zong zong di kamo purna ni ma se huat na le tumlok na awang at ni kanilo. Kan insual boy awanga in mitlelam del kaninen. Aman dua kalaksa ka yan kay tipagtaan. So he's admitted. Yes. Now, okay, now let us read now the evidence, keeping what he has said in mind, what he has said in his appeal in mind.
My lord, even it was not pre-planned, my lord, from this evidence of the PW number 6, my lord.
Assuming there was provocation, the provocation has to be the reaction has to be proportionate to the provocation.
Yes,
Supposing a child comes to you and slaps you in your leg or in your arm, will you take a cricket bat and bash his head? If you do that, will it be proportional? This is it depends.
yes,
One is hitting you, throwing a mug at you. or a cup at you, you cannot stab him. And everywhere, multiple stab wounds in the neck, face, scalp. And not only that, you burn his body also on top of that.
And my lord, from his memo of appeal, also he stated that he after throwing the mark, he attacked the victim, attacked him with a
But
knife. My lord.
that is an afterthought.
Evidence.
Where's the evidence? Where is that? Why didn't you take that evidence when you were given the chance? Why didn't you give evidence in the trial court? Why now?
Once did you mention all that?
Also, my lord, regarding the discovery of the weapon, there was it was seized after 10 days from the incidents. From the
How was it recovered?
it's from the disclosure statement.
Oh, disclosure or your disclosure statement?
Yes, but my lord, the knife was not proof that it connected to the crime.
But you have admitted now in your appeal. What about your 164 statement? Did you?
No, my lord.
What about your
My 164 statement, my lord, regarding the aspect of voluntariness, my lord, that on his petition, my lord, he stated that he made a judicial confession because the case IO just assured him that he would get a shorter jail time if he confessed before the magistrate.
We don't know what happened between you and the police. We only know what's before us.
And my lord, the judicial confession does not also corroborate medical examination, my lord. In his judicial confession, he stated that I used the knife that I have with me to chop his left forehead twice. All the injuries are on the right side now.
You see, while you're doing something, I don't know. Do you say that I'm going to hit it exactly there? Have you ever cut a chicken or something on the meat? Are you very good at cutting? You try this side, you most probably hit the left side. Unless you are a butcher and you know how to use a knife properly. When you cut fish, or you cut, say, a big boned chicken, sometimes you want to hit one side of the chicken, but you hit the other side of
Written reference that injury was not caused by him, then he should have caused that.
My lord, regarding this, when the FIR was lodged, five suspects has been arrested. That PW number 7 and PW number 8, who was last seen together with the victim, my lord, and knife and suspected blood stain on the polythene has been seized from them, my lord.
Just tell us one thing. Why should we not believe your appeal petition? Is it your case that the appeal petition submitted by your client, by the convict, should not be considered at all? It is a false appeal, fabricated document. Is it?
My lord, the petition was written by someone from the jail.
So it is not his petition. It is not his appeal. So this entire appeal goes. Why should we? So if it was not submitted by him, why are we hearing this case? Have you taken the plea that this appeal is not the appeal filed by the convict?
No, my lord.
Is it your plea that the contents of the appeal filed by the convict is false, then now what are we supposed to do? Can we turn a blind eye to the appeal petition and the contents that are in it? We don't have to accept each and every requirement made, but we cannot turn a blind eye to all of the contents here.
Yes. And my lord, even regarding the statement he made in his petition, my lord, he has stated that his judicial confession was not recorded as actually he narrated them.
Did you take that plea anytime? Was the judicial officer who recorded your statement, was he or she examined?
Yes, my lord.
PW number?
PW number 26, my lord, page 157.
157.
Yes, my lord. If I may read that.
Yes.
On 7/4/2020 at 12 noon, accused Wojtek was brought before me for recording his confessional statement. I had explained to the accused that recording of his confessional statement or not is at his option. I also informed him of the possible consequence of recording his statement, and I also gave him a reflection time as prescribed by the CRPC. At around 1 p.m., I had recorded the confessional statement of the accused, which are exhibited as Exhibit E4. I also affixed my signature, which was exhibited as Exhibit 4A, cross-examination by defense counsel. It is a fact that I do not know whether the accused had engaged counsel or not at the time of recording confessional statement. It is a fact that I have given him about an hour for reflection time when I have placed him under the supervision of the court staff. It is also a fact that no police personnel were present in or outside the courtroom while recording confessional statement. It is also a fact that the accused appeared to be calm and peaceful at the time of recording his confessional statement. It is not a fact that I am deposing falsely before the court today.
So where is the question put by the defense counsel
It
that
was
the
not
contents
challenged.
of the confessional statement is wrong? Nothing is there.
It's not challenged.
Huh?
It was not challenged by the defense
Correct.
counsel.
Now can you challenge it now?
No, no.
Then what do you mean?
And
So you have admitted to the contents of your confessional statement.
yes, but from as part the confessional 164 statement, my lord, the
It cannot be the basis for conviction,
Yes,
but
my
it
lord.
can corroborate.
yes, my lord,
So it corroborates the circumstantial evidence.
yes, but yes, but my lord, there was a previous abuse by the victim, my lord.
Huh?
Previous abuse by the victim, my lord.
Previous abuse.
Yes, my lord.
The victim was
mentally.
previously abused or victim
No.
abused.
Yes, my lord. By not giving his full salary, my lord.
Okay. Victim abused the appellant by not giving full salary.
Yes, my lord.
Who has said this? Which witness has said this?
My lord. On his judicial confession.
Oh, yeah. So, motive. That's the motive.
Yes.
So,
But regarding the motive, my
you
lord.
see-
Regarding the motive, my lord.
you see, in circumstantial evidence, motive becomes important.
Yes.
But where there is an eyewitness, there is no requirement of motive because they have seen the act. But in a circumstantial evidence, what is required is, since no one has seen it, so the court has to figure out as to why this has happened. Now you are providing the motive of.
No, my lord. One thing is that, my lord, that his judicial confession was not voluntary, my lord. But it
Where
was
is
not.
that?
It was not challenged during the trial, my lord. But
You were given reflection time.
only 1 hour. And my lord, I was not given chance to consult my counsel, my lord. The
Show me some ruling which says that you have to be given time to consult your counsel.
my lord.
And
You-
where is your evidence that you had asked for time to consult your counsel?
My lord, I was arrested continuously, my lord. First, I was arrested on 22, 2020, and released on the following day. And again, I was arrested on 26 and was again released on 27. And lastly, I was arrested on 29, my lord. And after I was arrested, my lord, on 7/4/2020, I was brought to the magistrate to confess, to record my confessional statement.
Yes. Where is the circumstantial evidence?
Your Lordship, the case which unfold is this. Whatever I'm going to say is on the record, but I will not point out the pages.
No, you have to point it out.
Okay.
Because we have got to start turning the pages later on.
All right. Your Lordship, my learned friend have already shown the motive first. And the second is that the story is that on that fateful day, the accused, along with his friend, went to Aizawl, and then they came back on the same day, and they reached Aizawl at around 7:30 p.m. And then after that, he have requested one of his friend, who is the prosecution witness number 4, I believe, to accompany him to one of his friends to see his in Swalwai, his poultry. And then that person who is a prosecution witness have denied because he have to visit his cousin. And then on his way to the cousin's house, he saw La Shwaitea, that is the accused, at the shop of his sister. The shop of his sister is about 5 to 10 minutes walk from the petrol pump, that is the place of incident, the place of occurrence.
Where is that evidence?
It's a PW number 6. Yes, PW number 6, page 137.
Page 137. PW 6.
6, yes.
Yeah. Page 6. Yes.
Yes,
Where does it say that it's 10 minutes from the petrol pump?
it's in the cross-examination. 138, number 5. Indra is the sister of the appellant accused.
Who?
appellant accused sister. The PW number 6 have stated that he saw the accused appellant in the shop of Indra, that is the sister of the appellant.
Indra.
Yes,
Indra
at around 8 to
is
8
sister of appellant.
appellant. 8 to 8:20 p.m. And then we know that the place is like 5 to 10 minutes walk. And the incident happened sometime in about 9:40 p.m. Between 9:40.
Between 9 and 9:40.
Yes, 9:40. In the FIR is 9:40, and from the evidence that is adduced before the learned trial court, it happens in and around that time, about 9. So the prosecution witness, have seen him 5 minutes away from the place of occurrence at around 8:30 p.m. Now, let's assume that the incident happened around 9:40, and the last person in the deposition, the witness who saw the appellant, was around 8:30 p.m. Let's say he took around another 10 minutes to sit with the sister, and then another 10 minutes to walk to the petrol pump, and the altercation took place for about 15 minutes. And then the incident has brought to light to the community only when the fire was set to the house of the victim. So the timeline is all in place because of the
When did the house start burning?
sometime in about 9:40. There is no specific time mentioned. Around 9:40.
Was it completely burnt, house of the victim?
It's burning down, his quarter,
Burned down.
burned up. That is from the records available. And
How did the learned trial court come to a finding that there was circumstantial evidence against the appellant?
because
What was the basis?
the basis is that the reasoning was given in para number 7, page number 100, citing the apex court authority in how to the factors to be considered: the type of weapon used, the accused carried the weapon and picked it up to the scene, whether the blow was directed to the crucial portion of the body, the amount of force used to cause harm.
No, we want to know the facts of the case, not the law.
Yes. So that is how you come to the facts. Is that I will come to that because since it's a circumstantial evidence. So first we know of the motive. Second is that we know that he was last seen sometime in the vicinity.
Vicinity, okay.
Yes. And then after that, he have admittedly in 313, even though he did not specifically deny it, but he by silent, he did not mention anything. He
No,
said that
no. Here's, what do you mean you are silent?
in 313 he did not say anything. But in 313, what I would like to point out is that
No, he said that no, it is not true.
yes.
I did not see
Question
any-
number 2. The evidence against you is that the pump manager had provoked you by using his special cup. As a result, you strike him. What do you have to say? No, I did not see any special cup. And I do not know whether he had any special cup or not. This implies that he was present at the
Mr.
scene.
Madam, you see, you cannot convict a person on the basis of an explanation given under section 3.
I understand. I'm going to come back.
So please
to this.
do not refer to 313. For you see, the circumstantial evidence has to be culled out from the evidence given by the prosecution witness.
Correct. That is why I'm pointing out, so as to
You are
make the
pointing
chain
out
complete.
3 and 3, madam. You cannot point out 313. 313 is only It's only an opportunity given to the convict, the accused, to explain the evidence that has been recorded against them. You have got to show from the evidence.
Your Lordship, with all due respect, this I'm using as a corroboration because
You cannot-
to complete the chain.
Before you corroborate, where is the chain?
That I'm
You
going
want to,
to.
no, you cannot put the cart before the horse. You please show us the horse, then you show us the corroboration. The
Okay.
cart.
In the the accused was last seen in the vicinity, and then after that the house was burned down, and after that around 5 people were arrested, out of which 2 were minor, and then the another 2 were discharged. And on his confession before the police, as well as the judicial statement, a judicial confession before the learned judge, he was convicted, and then he made the confession, and then his confession with the story of the PW number 6, all the story have interlinked, and it is
Show us that. You see, it's very easy to say that bus and that bus had an accident. Show us how.
okay.
Where is the evidence?
The
Interlinked. Where's the interlink? Where's the link?
confessional statements is in page number 208. It starts with 208. The preliminary question was asked, and the main the confessional statement is in page number 212. The translation is in 213.
Yes.
Yes. I started working at VEES filling station Burberry from mid-2018, and I worked there for about a year. While working here, the accountant, Mr. Singh, refused to give me my whole salary on numerous occasions. As I was supporting my younger siblings, I resigned on October 2019. On the night of 18 March 2020, I went to check out the poultry of my friend Vara, and as Vara was not there, I went to the home of Mr. Singh to drink water. I unfortunately drank using Mr. Singh's personal mug, and he got angry and threw his mug at me, saying, "You Mizos are filthy lot." In my anger, I used the knife that I have with me to chop his left forehead twice. As he was shouting, I slit his throat using the knife. I poured the kerosene in the house wall, and I also poured kerosene on my body to burn myself. I lit a paper from the flame of the cooking gas, and I was immensely scared. and I threw the flame towards the water
This
lamp.
is the confessional statement. We have seen it. Can the confessional statement be the basis of a conviction?
No, my lord, it is not used as the basis.
So show us the evidence, the circumstantial evidence.
My lord, if you please bear with me, I'm going through the circumstantial. If the circumstantial is the chain that is linked, then so I will have to go one by one.
Correct. But madam, one thing. When you go to confessional, you see, you want to corroborate some evidence, correct?
Yes,
You do not go, we are asking you not to go to the corroborative part.
yes.
You go to the evidence, the
Yes.
circumstantial evidence that is there.
If I may take your lordship kind attention to 1662. The evidence of the learned judge who have recorded the confessional statement is already read out, so I will not go to that. That is one part. Second is page number 162. This is the case IO. May I read, my lord?
Yes.
During investigation, 5 witnesses were thoroughly examined and reported their statements. One witness, Lal Duomi Pump Girl, stated that Pusinga and one Mizo tanker driver wearing blue kameez were standing at Pusinga's veranda just before the incident happened. The said driver was suspected to be proceeding to Lunglei. Hence, WT message was sent to OC Lunglei for detaining the said driver and handyman. The said driver and handyman were detained in Lunglei PS, locked up and brought to the PS along with the seized articles, that is, Dow and one polythene bag suspected to be carrying blood, and kept in Malkhana so-and-so. On 23/2020, the two suspected persons, tanker driver so-and-so and two pump boys so-and-so, were arrested after preparing arrest memo and informing that their grounds of arrest. Intimation was given to their relatives. They were thoroughly integrated, but they denied their involvement and their statements were recorded. The 5 arrested suspected persons were taken on 6 more days police custody and discharged from the liability of the case. But the 2 pump boys claimed to be juveniles, and in accordance with the order passed by the CJM Collective, they were released from police custody and produced before the principal JJB Collective. On 22/3/2020, the suspected person, Lashwaitea, of Walpivanglai, was brought to police station and examined and reported his statement and released on 23/3/2020. On 27/3/2020, the suspected person, Lashwaitea, was again brought to Konpui PS and thoroughly interrogated and reported his statement and again released on 28/3/2020. Contradictions were found in the statement of Lashwaitea. He was speaking lies and involved in this case. On 29/3/2020 at 2 p.m., Lashwaitea of Walpivanglai was arrested after preparing arrest memo and informing him his grounds of arrest, as well as intimation was given to his relatives. He was thoroughly integrated again. He admitted his guilt. He stated that he went to the victim's house to drink water. As he drank using Pusinga's cup, Pusinga got angry and knocked him with his herb. In turn, he got angry and attacked Pusinga with Dao kept there. Pusinga was dead, and so he got scared. He poured kerosene lying there to burn himself and lit a piece of paper from the cooking gas. But he escaped and threw the burning paper in the house. The offensive weapon were thrown in the jungle. I examined him and reported his statement. He was forwarded to the medical officer, PHC Konpui, for medical examination to ascertain whether he is fit to kept in custody, and not the medical officer who examined him opined that he is fit to be kept in custody for 24 hours. The disclosure statement of the accused was prepared on his free will in presence of two reliable witnesses. Disclosure statements were examined and their statements recorded.
Where is this disclosure statement?
It's in page number 226, I believe. Yes, 226. The translation is in 227.
So you see, now this disclosure statement, this can be a circumstantial evidence.
Yes.
Now, not the evidence of the IO. The IO's evidence is based on his investigation and on the inputs that he has received from the other witnesses.
Yes.
What have the other witnesses said?
The other witness, the items were seized from the black color T-shirts were seized from the possession of the sister of the accused, and then
What is the relevance of the black colored T-shirt?
because the blood stain that is there. If I may take your lordship to page number 22, this is the forwarding note that is sent to the for examination to the FSL. There are numbers of items that were seized, including the dao, that the knife that was used.
No. Have they connected the blood?
I'm going to
on-
come to that, my lord.
Okay.
Accused long sleeve shirt, black color, suspected to be blood stain mark as exhibited G, seized from the possession of the accused sister, so and so. Now, Your Lordship, if I may take Your Lordship kind attention to the examination of the officer who have examined the, who have made the report of the FSL. This is the page number 159.
Yes.
May I jump to from the first paragraph and then the third paragraph. On 9/4/2020, we received 2 exhibits containing Dow suspected blood stain and polythene bag with suspected blood stain from SDPO collusive in connection with KNP so and so. I examined the exhibits. However, blood were not detected from body exhibits. Further, on the same day, we received dried blood sample from the victim. Dow was with suspected blood stain, long pant, gray color of the accused with suspected blood stain, long sleeve shirt black color of the accused with suspected blood stain, which were packed and sealed in a polythene bag in connection with the said Conwy police station case. I conducted examination of the articles and traces of human blood was detected from the Dow, but the stains were insufficient for DNA profiling. Blood was not detected from the long pants gray color of the accused. However, I found that the blood stain of the long sleeve shirt black color of the accused were that of the victim. That is, so
Where is that?
the last line.
Okay.
I found that the blood stains of the long sleeve shirt of the accused were that of the accused, the victim. So now this is the circumstantial evidence. And the cross-examination consists of only 4 lines, 4 paragraphs. The report given is not contradicted and it's intact.
Anything else?
Yes, and the chain is complete because the chain is so complete that it goes to the guilt of the accused only. Now, Your Lordship, we know the weapon used. It is a dao is not a kitchen knife, long knife which is used for, I don't know how we put in English words. We used to use for one samna and all. Type.
You can use the word down.
Yes. So it's not a regular knife. Now, if we see the 164 statement of the 164 statement of the relatives of the accused, they have stated that this dao belonged to their family. But even though they have it starts from page number 12. Sorry, Your Lordship, it starts from page number 7. Qing Puyi Gan Qi is the mother of the accused. May I take Your Lordship straight to page number 9? How long have you owned the knife that is claimed as yours by you today? I do not know when we actually owned it. I believe my granddaughter Lalmunoi must have misplaced it at home, and I have not seen it for a very long time.
No, this
This is the
Qinghui,
Dao. Yeah.
was she a witness?
No, my lord, she was not made to be.
This has got no value.
Yes.
This has got no value.
Anyhow, Your Lordship,
She was the Caesar memo of the knife, or the dao, whatever.
It's 196. And 199 is the seizure of the memo of the long black pants and the shirts.
They should have given the size of the dao.
Nothing is mentioned.
Incident occurred when? Date?
Date of occurrence is 18/3/2020. It's around 9:40 p.m.
18/3.
18/3/2020.
That means seizure was made 1 day later.
Yes,
1 day later.
1 day.
Or 10 days later.
10 days later.
10 days later. That's what he said 10 days later. But then this seizure memo is of 19/3. When did the incident occur?
On 18/3/2020.
Then the seizure memo is of 19/3.
He was arrested only on 29/3/2020. And on the next day, a seizure was made.
Okay, he was arrested when?
29, my lord. 29/3.
Arrested on 29/3.
I'm deeply sorry, my lord. I have pointed out the wrong page. It's 205.
05.
Property was seized on 30/3/2020.
05. One dao.
Yes. From a jungle about 100 meters from the pier. But then the size of the dao is not mentioned.
Okay, this is what date?
That's
23. Property seized on 23 or 33.
33. 33.
But there was another dao seized on 19/3 also.
Yes, yes, because it was
Page 197.
as already pointed out. I have read out the case IO statement. They have arrested one truck driver and the handyman, and they have one dao. So they seized that. So that was why I was taking your lordship attention to the evidence of the case IO, because my learned friend have stated that another persons were also arrested. Just to make a clarification.
Disclosure statement was made on which date? Page 227. Let's see, 227.
30/3/2020. On the same date, it was recovered.
33. Anything else?
Yes, my lord, I would like to rely on the apex court authority. In 2006-10 SCC 681.
Ara?
15.
Yes.
Where an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution, but the nature and amount of evidence to be left by it to establish the charge cannot be the same degree as is required in other cases of circumstantial evidence. The burden would be of comparatively lighter for
Lighter character.
character. In view of Section 106 of Evidence Act, there will be a corresponding burden on the inmate of the house to give a cogent explanation as to how the crime was committed. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that the burden to establish the case lies entirely on the prosecution and there is no duty at all on the accused to offer any explanation. In 313, he did not give any explanation. He did not deny. He was neither there. He did not deny. He did not admit it. He accepted that he did not explain, but it can be inferred that he did not see the cup in question number 2. That was why I was referring to question number 2, because by implying that he was present in the scene, he said that he did not see the special cup, or nor he did not know that he had a special cup. Now, the weapon used is dao, and the provocation so as to provoke him is just a cup that was thrown at him, and then they slit, his throat was cut. I could understand that if he was punched from the back with the blunt side of the dao, then we could have understand, or maybe.
Any judgments on that?
Yes, my lord. On the blunt side, 2025 SCC online SC 602.
2025.
Here, in this case, the Supreme Court have briefly mentioned the parameters. In this case, the ultimate decision was that the case was converted as a culpable homicide, not amounting to murder. But then I'm going to use the ratio of paragraph number 12. From the evidence of the prosecution witness itself, paragraph number 12.
Yes, yes.
Yes. From the evidence of the prosecution witness itself, it is clear from the place of incident is near the house of the accused persons. The possibility of quarrel taking place on account of previous enmity between the accused and the deceased, and in a sudden fight in the heat of the moment, the appellant along with the co-accused assaulting the deceased cannot be ruled out. It can further be seen that the weapons used are a stick and the blunt side of the axe. These tools are easily available in the agricultural field. It is therefore cannot be said that there was any premeditation. It is further to be noted that the appellant is alleged to have used the stick, whereas the co-accused is said to have used the blunt side of the axe. If their intention is to kill the deceased, there was no reason as to why the co-accused would not have used the sharp side of the axe. So, Your Worship, he used dao and slit his throat, not punching on the vital part of the organs of the body. And then after that, availing himself to cool down, he even had the sense to light a paper from the stove of the deceased and burn down the house.
That seizure of the T-shirt is page 199. Seizure of the long sleeve T-shirt. Long pant, grey color.
It's
No, that is for
202. 202.
202. Long sleeve T-shirt.
Yes.
Who are the witnesses out here? Kaping Thanga. But Kaping Thanga in his evidence has said that, in his cross has said that he did not see any blood stain.
Because
Page
it's black color.
148.
It's black color, my lord. It's the we have gone through the evidence of the FSL, the officer who have conducted the FSL. He said that they have received a dried blood from the sample.
No, that is all right.
Yeah.
What I'm saying is, Kaping Thanga has said that it is a fact that I did not see any stain of blood on the long sleeve T-shirt seized by the police officer. And he's a Caesar witness. Page 148. Serial number 6. Of course, PW 13, who's also a witness, did not say anything regarding
Did not
that.
say anything.
Anyway, so that the FSL has found blood stains.
Yes, yes.
Anything else?
Yes, Your Lordship, the presuming but not admitting that the accused was wrongly given wrong advice to file the appeal and wrongly written. But then the circumstantial evidence that is shown in the record is so complete that it only brought to the guilt, it only point towards the guilt of the accused. So my only prayer is to uphold the decision of the learned trial court. Your Lordship.
Anything else?
My lord, if I may clarify regarding the motives, my lord.
Huh?
Motives.
Huh.
My lord, during the trial, the prosecution has relied on the statement of the PW number 2 and PW number 11, a statement for motive behind the commission of the crime, as both disposed that the appellant was terminated by the victim from his employment. But my lord, if I may take your lordship to PW number 4, that is on page 133. 133, my lord.
Yes.
My lord, if I may read only the relevant portion, my lord.
Yes, yes.
Cross-examination by defense counsel. It is a fact that those who quit their job from the petrol pump had done with their own choice. And then on the next page, it is a fact that Mr. Zalian Sunga is the only one who terminated the employee of the petrol pump and not Pusinga. So, my lord, this contradict the statement of the
What?
on 134, my lord.
134, yes.
Page 134.
Yeah.
It is a fact that Mr. Zalian Sunga is the only one who terminated the employee of the petrol pump and not Pusinga. So PW number 2 and 11 were stating that the accused was terminated by the victim from his employment. But from the evidence of PW number 4, he stated that,
So PW number 4 evidence is more reliable according to you
Yes, my lord.
than 2 and 11. Why?
yes, my lord, because
He's more handsome. He's more handsome. He's taller, or what? Why?
Yes, my
Why
lord,
should we
cause-
believe Why should we believe PW4 and not 2 and 11?
PW number 4 worked since 2011 on that filling station, and PW number 2 only worked for 2018, my lord.
So how does it matter? How does it? So you mean that the longer person works, he's more reliable, is it? So a person who joins service at the age of 19 years, if he has a quarrel with another person of the same organization, so according to your logic, the person who has worked for a longer period should be believed.
And my lord, regarding the blood-stained T-shirt, my lord, the blood-stained T-shirt was seized from PW number 17, wherein she stated that the blood-stained clothes were already washed by the accused, my lord, Appellant, before the seizure was made.
Where?
It was on page 151, my lord. If I may read, my lord. In the afternoon of 30/3/2023, police personnel came to our residence and took one black T-shirt which belonged to the accused. I have nothing more to say. Cross-examination. It is affected the accused was not present when seizure was made. It is affected police personnel straight away took the long-sleeve T-shirt from our resident, saying that they needed the same. It is affected myself and accused to wash his clothes, and I do not see any kind of blood stain on the long-sleeve T-shirt as it was already washed by the accused.
No, just because it is washed does not mean that it has to be, it completely disappears. In some cases, it doesn't happen. It still remains in the fiber at times.
Yes.
Anyway, so it was washed. Okay.
Yes, my lord, all the prosecution witness would personally know the accused has said that he has a good character, my lord. So,
Good character,
yes, my lord, he's of good character.
but dangerous when angry. That's what your case is all about. Because you have said that because he was provoked, he killed. So he becomes dangerous when he is angry. Correct?
Yes, my lord.
Or what? It's not correct.
It's correct, my lord.
So his character only, he's got a Dr. Jekyll, Dr. Hyde kind of syndrome. That's all.
My lord.
Okay, heard, Mr.
Welcome to Intara, my lord.
Lalnamdin Thara, Learned Amicus, and Mrs. Mary L. Camper, Learned APP. Hearing concluded, judgment reserved.
Item 4.
Yes,
May it please your lordships.
yes.
My lord, this is also a jail appeal filed by the incident appellant against the judgment and order which has been passed by the learned trial court
Yes.
dated 17/7 and the order of 17/7/2023
Yes.
and the order of conviction on 18/7/2023.
Yes.
My lord, before coming to the facts of the case, my lord, I would like to state that I will try to impress this honorable court on 3 points. That is, that the charge has been framed under the wrong provisions of law.
Charge framed under wrong provision.
Yes, and that it has not been altered prior to the pronouncement of the judgment. And my second point will be that according to the impugned judgment, there were no eyewitnesses and therefore circumstantial evidences were relied for conviction of the innocent appellant. However, my lord, the chain of circumstances there was a gap, and that gap was not been has not been filled by the prosecution. And my third points of arguments would be that the ingredients of Section 300 IPC has not been proved by the prosecution beyond reasonable doubt. The brief facts, according to the prosecution, my lord, this from page number 112, this is the final report submitted by the case IO. Is that, my lord, on 5th March 2017, a suo motu FIR was filed by the deputy SP, who is also the instant prosecution witness number 1, to the effect that consequent to his inquiry,
Just
on-
tell me something.
Yes,
This
madam.
appeal has been filed by whom?
by the accused appellant, my lord.
By the accused.
Yes, this is a jail appeal.
Okay. So this is where he shot his own son.
My lord, according to the prosecution story, my lord.
And according to your story, you did not shoot anybody.
No, my lord, my story, and according to the memo of appeal, is that I was,
I'm not asking
Yes.
a memo of appeal. I'm asking you.
my lord, my lord.
Mm.
My intention was to shoot the television set.
Okay.
However, I did not know when the victim, my son, had come in between the television set
Okay.
and the.
So he was shot by you.
Uh,
Naturally, if you tried to
Madam.
shoot the television set, and
Madam.
while shooting the television set, he came between you and the TV. Basically, you shot him, though
That-
unintentionally.
that was my story.
So that is your story. So
Yes.
the long and short of it is that
Yes.
the shooting of your son was not intentional.
Yes, my lord.
So it should come under section 304
However, my lord,
or what?
in my appeal memo,
Ah,
that as I was convicted under section 302, even though the ingredients of section 300 were not proved, all the ingredients were not proved.
Ah.
Therefore, I am liable to acquittal,
You are
And
liable
for-
to be
for acquittal and for setting aside
Acquittal?
of the
acquitted.
yes, for
When,
setting
when,
aside
when
of
it,
this
when it is
im-
an
impugn-
admitted fact that you
My
have
lord.
shot somebody,
yes.
you are entitled to acquittal. Show me the
My
law.
lord, this is at page number 69.
Page
Page
69.
number 69, this is the prayer portion.
Page 69. No,
My lord,
okay, anyway.
Yes.
Okay.
if
Let's see what does page 69 say.
the last paragraph,
Paragraph. Yes.
this is the prayer of the appellant, my lord. In the facts and
No,
circumstances.
you see,
Yes.
Mr. Counsel, we are an amicus.
Yes.
You cannot go by the prayer. If they ask you for the moon, you cannot give them the moon.
My lord,
As a officer of the court who is to assist the court,
my lord.
and with the knowledge that you have, which your client does not have,
Yes.
you have to be practical in your submission. Okay.
Yes.
The very fact that you have killed your son is not in doubt. The only thing is whether it is murder or culpable homicide,
My lord,
not amounting to murder. That's all.
my lord.
Now, if it is not murder, then it will be culpable homicide.
My lord.
You cannot run away from that fact. Now, which provision under the IPC should be made applicable to you? Is there any law which says that if I have killed somebody without any intention, I should be acquitted?
No, my lord. My lord,
Hmm?
then I will come under section 304, my lord.
Yes, say that. That is what. You cannot say that I should be acquitted. You cannot make a
I-
unreasonable submission, you know.
My lord.
You see, every little thing that you say has to be based on the provisions of law.
Yes, my lord.
Otherwise, if you do not make your submissions on the basis of the law, then how are we going to help you?
My lord.
Because we cannot make the law as we deem fit or think it proper. We have got to we have got to give our judgments as per the law laid down
My lord.
in the act.
I am only making submission on behalf of the
You
appellant,
make,
as is prayer,
but
my
you have
lord.
got to make
Yes.
practical submissions.
Hello.
Don't say that I want a cake made from the moon or something like that. It's not possible. Because we as a judge have to pass orders in terms of the law. There has to be a source of power for exercising it.
My lord.
If you can show us the law that we can acquit because of unintentional shooting or killing, we'll acquit. But you show us the law.
If I may continue, my lord.
Yes, yes.
Regarding my first point of for submission, my lord, if your lordship could kindly come to page number 2. Page number 2 of the paper book. In the last paragraph.
Yes.
In the last paragraph, it is clearly written, stated that the instant appellant has been charged under section 320 IPC.
These are
Yes, my lord, I will come to even to the judgment.
you see,
Yes.
yeah, these are mistakes, minor mistakes.
Yes.
These are minor mistakes. Where is your application saying that this is a mistake?
This is there.
Have you
my lord.
was your defense made on the basis of section 320?
I have written. I have submitted a written argument. Counsel who was present in the trial court had submitted written submission
That is just a
taking
minor-
this defense, my lord. Yes.
inadvertent error. That minor. Everyone knows that. It's out here. You have committed an offence punishable under 302. It's here on top.
My lord.
This goes.
Even this has been reflected in the judgment. However, my lord, if your lordship could come to page number 59.
359.
Page number 59.
Who is the judge?
This is Srimati Musang Goli Saibal. If your lordship could come to page number 59 at paragraph 15. The conviction is also under section 320.
Okay, mistakes are committed.
My lord.
Huh? Yeah. This is a mistake. That we can correct.
And
You see, if you can show this court that you had not been given a chance to defend yourself
my lord.
with regard to a charge under section 302, then okay. So let us see what 320 is. Please give us the IPC. Was your defense on the basis of 320?
There were no defense, my lord.
Then, yeah. So your defense made.
In fact, the
So all your cross-examination of the witnesses was on the belief that the charge was under 302. Correct.
my lord.
Not under 320. Then
This 302 talks about grievous hurt.
he's dead.
How,
There's no
however,
question
my
of
lord,
grievous hurt.
there is a provision that under section 216 of CRPC.
Alteration.
Yes, my lord. That has not been done.
Let us see if you are liable to get the benefit of 304 part 1 or part 2. Let us see.
My lord, in this regard, since this is my first submission, my lord, I would like to substantiate my submission.
With regard to
this-
what? The framing wrong provision.
Yes, my lord. 1961, Volume 1 Criminal Law Journal 104. This is passed by this honorable court, my lord.
1961.
Volume 1 Criminal Law Journal 104.
Yes. What does it say?
Paragraph number 4, 5 and 6, man. 4, 5 and 6. If I may read.
Yes.
It appeared from the way in which the trial and the appeal proceeded that neither the magistrate nor the appellate court looked into the charge at all. It is seen that the charge was framed by one magistrate, while the actual trial took place before another magistrate. The attention of the magistrate is drawn to chapter 19 of CRPC dealing with the form of charges. Another objectionable feature in this trial was that while the charge against the two petitioners was framed only under section 326 IPC, they were convicted by the magistrate under section 326 read with section 34 IPC. The learned magistrate remarked that though section 34 IPC was omitted in the charge, both the accused were liable under sections 326 34 IPC as they had the common intention to cause grievous hurt to PWs 4 and 5, and the absence of a charge under section 34 IPC was curable by section 537 CRPC, and that he was satisfied that the accused were not misled or prejudiced in any way by the said omission. Now, paragraph number 6. This is clearly not the way to conduct the proceedings in the magistrate's court, nor had the magistrate any authority to say that the defect in the procedure in his own court would be curable by section 537 CRPC, that it is a matter for the courts exercising appellate or revisional powers to decide.
This is a different case,
My
Mr.
lord.
Counsel. This is where the charge under 34 was not added, the common intention was not added. Out here,
My
there's
lord.
no question. Out here, there's a question of, instead of making 302, here, by mistake, it has been written 320. But if you see the framing of charge, out there it is framed under 302. By mistake, it has been made under 320.
And my lord,
That is
my
no
humble
problem.
yes, my humble submission is that
This
the
case
learned-
is not applicable.
the learned trial court ought to have altered the charge during the trial, and that
Alter the charge to what?
my lord, as 302 instead of 320.
No. It is already 302. It's already 302. Sorry. You see, you come to the no. That mistake out here that
Yes,
that court
yes,
has
my
made, that doesn't change the fact that this is under 302. You see, it says you shot your own son, Siranur Moya, at his right shoulder region, and your son died on the same night. You shot your son while he was having dinner in your house with a 12-bore SBBL gun, and thereby committed an offense punishable under section 302 IPC.
My lord.
It is here in the middle. It
My
is
lord.
here. That below that because they made a mistake here. That doesn't change the fact that 302 is the charge, because you cannot charge a person with 320 when he dies, when there is a death. That argument fails. Next argument.
My lord,
Not waste
my
time.
next point regarding circumstantial evidence, my lord.
Yes.
If your lordship could come to page number 48 at paragraph number 10.
Page
Page number 48,
48. Yes.
paragraph number 10. I will read it.
Yes.
In the instant case, PW number 2, 3, 4, and 5 were present during the alleged incident. They were watching a television which got shut down the very moment they heard a gunshot sound. None of them saw the actual incident taking place in the kitchen. All of them turned around upon hearing the gunshot sound and ran to the kitchen. Hence, the case is to be proved by circumstantial evidence, in which case the settled law is that the circumstances from which the conclusion of guilt is drawn should be fully proved, and such circumstances must be conclusive in nature. So, yes. And however, my lord, in this regard, my submission is that the prosecution has not proved that the circumstantial evidences were complete, my lord.
Okay.
In this regard, my lord, I would like to,
No. You see, before going into the law, please tell us the facts.
my lord,
Now, when your son died, where were you? Were you with your son, or you were somewhere outside the house, or partying somewhere, or what were you doing?
my lord, my son was having dinner, and I was also in the dinner table.
Oh, you were there also.
Yes, my lord. I was also in the dinner
So,
table.
how did your son
And-
die according to you? He shot himself.
And the prosecution, according to the
No, according to you.
My lord,
Please,
no,
you see,
no,
you
no.
have got to stand on your own legs.
Yes.
What is your story? We want to hear your story. The prosecution will say their
My-
side of the story.
yes.
Your story. What happened?
My story was that I tried to shut down the television set that was going on by, and I showed the television set. However, I do not know as to when my son has come in between the television set and myself. That is my story. My story.
End of the matter. So why are you trying to go into what prosecution says?
My lord.
You want only your side of the story.
My lord.
So it is admitted by you that by somehow your son came in between
Yes,
your gun and the TV.
exactly, my lord. That is also what I've stated in 3139.
Fever.
Yes.
Okay, that is also. So now let us see why should any of the exception, section 300 is not attractive, whether 304 part 1 or part 2 is attractive. Part 1 cannot be attracted, I think. I think it will be part 2 or part 1. Part 1 also, I don't know. Why should it be attractive?
Because, my lord, I have no intention to shoot. Yes, and that intention, this was my third submission that I will come into. That intention has not been proved. That I will come into. Now,
Now you tell us why. How?
regarding the circumstantial evidences, my lord.
No, okay, but how did he suddenly come into a line of fire? He was having dinner.
Yes,
You were trying to shoot the TV.
yes.
Was he having dinner standing up or sitting in the dining table?
And according to the
And then he
prosecution,
suddenly jumped and then came right directly.
according to the prosecution, witness number 2, who is also my daughter, she had seen that my son collapsing on the chair.
No, you have got to tell us one thing. You see, dining table is, I don't know how many seater, 6 seater, 4 seater,
That has not been
8 seater.
provided.
Okay. Now, son is here. Say,
Yes.
son is here eating dinner. Father is here. TV is where? TV is behind the son or TV is somewhere
TV is
else?
behind the
sun.
Yes.
Oh, TV behind the sun. Exactly, direct line of fire.
my lord.
So how did you try to shoot the TV? Through him or through?
No, my lord. Not through him.
Then how?
I do not know.
Standing up?
I do
Did you
not
stand
know,
up and shoot or what?
I do not
Wait.
know as to when my son
No,
had
no.
come into
I'm asking you.
Yes.
How did you shoot? Did you shoot the TV while sitting, standing, or how did you shoot? Or through him? Because if he's sitting and having dinner,
My lord.
you'll have to stand up and shoot probably, unless it's in the ceiling or somewhere. How did it happen?
My lord, there is a sketch map
Okay,
at page number 102.
102.
Yes. There is a serial number 2. There is a dining table, and the D1, the serial number 1. That is a plastic chair in which my son was sitting.
Okay, and you are at 3.
And this is also another
Plastic chair.
Yes,
And where were you?
my lord. The story is that I have entered the bedroom and took out the gun.
Oh, then you came back.
Yes, and shot the two.
Okay, where is the bedroom? Bedroom is
Bedroom
8.
is
And
yes.
TV is this, TV is,
TV is at number 5 on the right bottom.
okay, right.
Right bottom.
You must be a very bad marksman. Huh? Sun is here, TV is there. How can they, unless they're cockeyed or something?
And my lord, even the television set was
And you
shut
missed the
down. No,
you
no, no.
you missed the TV.
No, my lord.
You didn't miss the TV.
Yes.
You didn't miss your son. You didn't miss your TV also.
No, yes,
So you shot them both.
my lord. The TV was shot. The TV was shot. Now, my lord, regarding this
TV is
circumstantial,
right. TV is right. And the bedroom door is near it.
regarding
I think that yeah. Could be. Now we have to see the evidence. Yes. How did your son come forward? Why did he come in the line of fire? How did he come in the line of fire?
That was unknown to me.
You were holding the gun. You were seeing. Unknown to you. Why suddenly? How can you have selective amnesia?
I have also stated in 313, my lord, that I do
Suddenly
not,
he came.
yes, I do not know how he came in between. If I may be allowed
But
to,
that is your side of the story.
my lord, if I may be allowed to continue,
Yes,
my
yes,
lord,
yes.
regarding this circumstantial evidence. Now, my lord, if your lordship could kindly come to the deposition of the inquiry officer, PW number 1, at page number 11. Page number 11. From the 9th line from the top. From 9th line from the top,
Yes.
if I may read.
Yes.
The dead body was already taken out from the actual place of occurrence before the police arrived and kept in an unoccupied house of H. Lalbuata of Bongkon. There and then inquest over the dead body was conducted by me, and I found during the course of inquest that the deceased sustained bullet injury on his upper left rib with an exit wound on upper right rib. And even in his cross-examination at page number 13, paragraph number 4, that same deposition was made, that the bullet entry was on the left side of the body, and exit wound can be seen on the right side. And same statement, my lord, same statement has been made by PW number 14 at paragraph at page number 32. Page number 32.
Yes.
In his cross-examination at paragraph number 7. Page number 32, cross-examination, paragraph 7, if I may read. It is a fact that from the examined t-shirt, the lead slug entered from the left side and exit to the right side. And similar statement has been made by the case IO, PW number 16, at page number 35. Page number 35, second paragraph, from the 4th line. During inquest, gunshot in entry wound of about 2.5 centimeters in diameter below left shoulder, about 7 centimeters away from the left armpit, piercing through the left rib was found, whereas exit gunshot wound was found below right shoulder. However, my lord, if your lordship could come to page number 31, PW 13. PW 13, she is the medical officer who has first examined the deceased while the dead body was brought at Greenwood Hospital.
Yes.
On her examination, on Roman number 1 and 2, gunshot entry wound over right scapular region, and gunshot exit wound over left scapular region.
So,
now there is a contradiction regarding the entry wound of the bullet, my lord.
correct.
And again, my lord, this one is this is important, my lord. The deposition of the PW number 15 at page number 34. PW number 15, he is the head of department in forensic medicine department.
Page.
Page number 34. 34. PW number 15. HOD Forensic Medicine Department, Civil Hospital, Aizawl. Now, his statements in his depositions and in the uh, re- uh, report that he has prepared contradicts itself, my lord. Here he says, in his cross-examination, my lord, paragraph number 4, the entry wound below 11 centimeters on the right shoulder, 7 centimeters away from the left axillary armpit, piercing through the left sixth rib, is 2.5 centimeter in diameter.
So, Mr. What are you trying to get at? What are you trying to, what is
My lord-
your objective? You saying?
My lord, that the entry wound of the bullet entry wound,
Look, look, one thing is this.
yes,
When you have admitted to the fact that it was your shot that killed your son, whether it entered from the right or from the left,
my lord,
depending upon the witnesses who are probably, some of them are not even aware, have never shot a gun in their life also, some of them. How does it matter? What are you trying to project, or what are you
My
trying
lord,
to prove?
there is a remarkable gap, my lord, in the circumstantial evidence,
No,
and that has not been
so
that has not
you
been
mean he did not shoot? Or
that
what?
has not been filled, my lord.
Trying to say that you did not shoot your son. He did not die of a bullet.
My lord, this case has not been proved beyond reasonable doubt so as to convict and sentence the appellant under section 302. Man. That is what I'm trying to impress this for me.
You see, you're not making sense. On the one hand, you're saying that you did not know how your son suddenly came between you and the TV. On the other hand, you're saying that the entry wound, some are saying left side, some are saying right side.
Yes.
Now, but the fact remains is that you were the one who shot. Is it your case that somebody else shot the gun?
No, my lord.
You did not shoot. You shot the TV, but you did not shoot the son.
Yes.
Your son died because of something else.
No, my son. I do not know how
someone
how
must have a
yes,
gun there.
how my son has come in between the television set that I have shot.
Did someone
lord,
else was there someone else in the room with another gun?
I humbly
So you
submit
say
that my
you did not
yes,
shoot your son, you shot the TV?
My lord.
Someone else must have shot your gun.
I
Your son
humbly-
with a
Is that your
different gun.
case that you did not shoot, somebody else shot your son?
no, my lord.
Oh,
I humbly submit that I cannot go beyond what has been recorded.
No,
And
no,
I-
Mr. Counsel,
yes.
it's okay. You don't go or you go, whatever. But
Mhm.
please try to have an objective in mind.
Yes.
On the one hand, you are saying, yes, I shot the TV, but suddenly I do not know how my son came in the line of
Yes.
fire and due to which he was killed. On the other hand, you are saying that some people have said that he has been shot from the right side. Some people say that he has been shot from the left side. Now, how does it make a difference when it is your admitted fact that you are the one who shot it?
My lord, since the impugned order had relied that since there were no eyewitnesses to the incident, therefore circumstantial evidence.
That is why 106 is very important.
Yes, my lord.
106 that 106 talks about what happens in the confines of a house. The secret is known only to you and the other occupant therein.
I am yes, my lord.
And we do not understand what you're trying to get at.
And my lord, again in the deposition of the case IO, my lord.
See, you stick to one plea.
Yes.
That this is not 302, this has to be altered to 304.
My
And
lord.
come to only that.
My lord, my lord.
Okay, not whether he was shot left side, right side. That doesn't matter. He was shot. You had the gun.
You're not denying it also.
So
How does it matter whether you shot it
And-
from the left, from the top, from bottom? You shot him anyway.
So now, try to show that it's
yes.
302.
Yes.
It's not 302, it is 304.
Yes, my lord.
No intention. Show us that.
What I was trying to impress this honorable court is that the circumstances has not been
So he should be acquitted. He was not
My lord.
shot. He did not die. He did not die out of a bullet wound, is it?
according to the PME report, he had died of bullet.
And who had the gun?
The gun,
Who had the gun?
No, my lord.
You are,
The
you
gun
are
belongs.
holding a gun
The
in
gun
one hand,
belongs to
eating
my.
dinner with the other.
The
and he
gun
shot
belongs
himself.
to my brother. Anyway, my lord, if I may be allowed to yes,
304.
regarding this non-proving of the ingredients of 300 IPC, and that, my lord, this honorable court may consider that even though the prayer of the appellant
Even
may not be
anything, but
applicable.
you're helping him.
Yes, that may not be applicable at this stage, my lord. Then his prayer may, that this honorable court may consider another relief. My lord.
304. So how
Yes,
do you
my
do
lord.
304?
My lord,
Part two.
now regarding the intentions, my lord, the learned trial court had stated from paragraph from page number 50, paragraph 12. Page number 50, if I may read, from paragraph number 12.
Page?
Page number 50, 50. My lord, I'll read from page number 51. From the last paragraph. Intention is different from other mental elements such as knowledge and likely to cause death, and it should be distinguished from motive, which is the force that fuels intent. Intent and motive focus on an individual's mental state, and both are often conflated. Intent is concerned about individual's decision to carry out a specific action, while motive is concerned about the underlying reasons for carrying out the action. In the case of State of Haryana versus Pala and others, it was held that the apex court that the intent is locked in the assailant's heart and can only be inferred from attending act and circumstances. Proving intent or purpose is a daunting job for the judiciary, and thus attention should be given to the specifics of any case at the time of its commission. Thus, in the light of the decision of the apex court, the nature of the crime, the type of weapon used by the accused, the extent of injury, the part of the body on which the injury was inflicted, and the conduct of the accused before and after commission of the act would help in validating the establishment of culpable purpose, and the intention will be assumed even if there is no exact proof of existence of the same. So, my lord, the learned trial court has relied on this paragraph, that the intention, that is one of the key ingredients of section 300, need not be proved, but can be inferred from the action manual. However, my lord, I have 4 judgments to produce in this regard, that the intention has to be proved, my lord, beyond reasonable doubt. In, my lord, 2016 volume 3 SCC 317, 2016 volume 3 SCC 317, this is Nankaunu versus State of UP,
Yes.
at paragraph 11, my lord. Paragraph 11, if I may read.
Yes.
Intention is different from motive. It is the intention with which the act is done that makes a difference in arriving at a conclusion whether the offense is culpable homicide or murder. The third clause of section 300 IPC consists of 2 parts. Under the first part, it must be proved that there was an intention to inflict the injury that is present, and under the second part, it must be proved that this injury was sufficient in the ordinary course of nature to cause death. So, my lord, intention under 300 has to be proved, my lord. And 2023 SCC online SC 857, 2023 SCC online SC 857. This is in the case of Anbazagan versus State, represented by Inspector of Police.
Para?
Para 31 and 32.
Yes.
31 and 32, if I may read.
Yes.
The phraseology of sections 299 and 300 respectively of IPC leaves no manner of doubt that under these sections, when it is said that a particular act in order to be punishable be done with such intention, the requisite intention must be proved by the prosecution. It must be proved that the accused aimed or desired that his act should lead to such and such consequences. For example, when under section 299 it is said, whoever causes death by doing an act with the intention of causing death, it must be proved that the accused, by doing the act intended to bring about the particular consequence, that is, causing of death. Similarly, when it is said that whoever causes death by doing an act with the intention of causing such bodily injury as is likely to cause death, it must be proved that the accused had the aim of causing such bodily injury as was likely to cause death. Thus, in order that the requirements of law with regard to intention may be satisfied for holding an offense of culpable homicide proved, it is necessary that any of the two specific intentions must be proved. Intentions has to be proved, my lord. And
Mr. Counsel, when you shoot somebody,
my lord,
it can be presumed that there's an intention, especially when the other person doesn't have anything to shoot back with. Now, you see, instead of going into the law, you should go into the facts. What is the testimony of the witnesses? Now, what is the testimony of this, the sister? Sister says, my father and my brother were having dinner at the kitchen on the table. Then at the time my father scolded my brother saying, you are so dirty, I am not in a mood to have dinner with you. Don't watch TV late at night. You disturb your sisters who are studying their lesson. My brother also talked back to my father. Thereafter I heard a gunfire inside our residence. This is what the evidence says. And now another thing. You see, come to the evidence of, you are going to the law. You have to go to the facts. You cannot, you've got to, the law has to support your facts. It is not that you read the law and then you try to mold the facts to what the law says. You see, now what does this PW3 say? He says that I heard the accused Soma say to his son that and I heard his son Zone Unmoya went inside their bedroom and take off his socks. Thereafter, Zone Unmoya came out from the bedroom and sat there on the dining chair in order to have dinner. I suddenly heard a gunshot and I immediately raced towards the kitchen. I saw the victim's son of Sima Soma slowly collapsing from his dinner chair at the floor. So what does it show?
however, my lord, in the cross-examinations, my lord.
Yes, you read. That is what. Don't go to the. This should come at the end.
My lord, my lord.
If the facts are similar,
Yes.
otherwise you are going the other way around. You're telling us the law
My lord.
without knowing whether the facts fit into the case.
Yes.
Yes.
In cross-examination of the PW number 2 at page number 15.
I think 1 o'clock. I think we'll take it up. I think my sister is having some problem, so tomorrow we'll continue.
My lord.
Okay. I don't think it will take too long.
Yes, my lord.
You see, you've got to be. You have, please go to the evidence.
My lord.
The law, though, everyone can read. The evidence has to be the thing that will either support your case or not. Okay, the evidence. You have got to show that it was unintentional. Because the evidence out here shows that it is intentional. Right. Heard Mr. Tilas Lakshima, learned amicus curiae. Also heard Miss Helen PP. List the matter. Linda. Linda list the matter tomorrow at Pathar. We'll do single bench at 2, huh?
I seek your lordship indulgence in mentioning part
Yes.
2. Item number 11, my lord.
Yes. Part 1,
Part 2, my lord.
part 2.
Yes.
Yes.
My senior, Mr. L. Pakoma, has some personal difficulties, so if the matter can be taken up after 2 weeks.
Okay, on the prayer made on behalf of Mr. Alpha Kama, this is the matter for today.
Similar order in my lord, item 9. In item 9, I'm responding number 2, 3, 4, 5, 6, 7.
Okay, for Alpha Kama, for respondents number 2, 3, 4, 5, 6, 8, 9, and 10.
Yes, my lord, item
thing,
number
huh?
12 as well.
12 also.
Yes, my lord.
What is this? Where is it?
Make appeals for the quantum, my lord.
Okay, so after 2 weeks, follow them. He's
Oblige.
for the appellant in item 12. Alpha Kama.
Oblige.
My lord, may I seek your indulgence in mentioning item number 1 and 4.
1 and 4, yes.
Yes, Senior Counsel Sri Ramzawa, he had to attend the funeral of his relative at Sechip. So
Okay.
he went to Sechip this morning.
Right, on the prayer for adjournment made on behalf of Mr. Sira Ramzawa, learned counsel for the appellant,
Yes.
for the appellant, on the ground that there is a family bereavement. This is the matter. After
Maybe.
a week. Yes,
I seek your lordship's indulgence. Your lordship, item number 2 of part 2.
yes.
This is state appeal. Since I was prepared for the DB matter, if the matter can come up tomorrow for hearing, not today.
Okay, it will be in the list.
All right. And my lord, item 3 is also my item, but the appellant's counsel, they're not here.
Okay, let it remain in the list.
And item 5 also, my lord, this is another state appeal. I'll talk to Mr. Lal Ramplanga, my lord. and
Okay,
we'll
okay.
see.
It'll be in the list if you all want to do it, you'll do it.
Okay.
Next.
Your lordship, if I may seek indulgence in mentioning part 2, item number 10.
Yes.
Because the main counsel, she's having some health issues.
Okay.
And if the matter may be listed after 2 weeks, and the consent has already been taken.
Huh?
Consent has already been taken.
Okay, right. On the prayer for adjournment made on behalf of the petitioner's counsel due to some health issues, this is the matter after
2 weeks.
2 weeks.
Seek your lordship's indulgence in mentioning item 13 of part 2.
Huh?
Item 13 of part 2.
Item 13, yes.
That's some family
Huh?
family events that upcoming family events are in the matter be listed after 2 weeks.
Family event.
I am for
What
the
family event?
Wedding.
We are having family events for 2 weeks.
No,
Everyone is
not-
having some family event. What are the events?
wedding.
Wedding, your wedding.
No one.
Then? Whose wedding?
We are related.
When?
On the 24th.
24th?
Yes.
Day after tomorrow.
Yes, they are.
My lord, I'm appearing for respondent number 2 in this matter. So if my appearance may be reflected, since I've already filed the wakalat, Mama.
Okay, what is this for? This is the criminal appeal against what?
Conviction that 376 clause 2A.
Okay.
10 years imprisonment and 30,000 fine.
Okay, right. On the prayer for adjournment made by Mr.
Barokuma.
Ralokuma to learned counsel for the appellant. This is the matter. And which is not objected to by Mrs. Lalmai Satifana for the response number 2. This is the matter. After
2 weeks.
2 weeks. Wedding is only day after tomorrow. What are you going to do after that?
2 weeks if lordship.
2 weeks.
Right.
Daily list for motion, item number 1.
Yes, what is your case?
Making this is a petition you are challenging the registration of the second FIR that is dated 29th of March 2024 as CNEO case number 3 of 2024.
Yes, the second FIR, second charge sheet.
Yeah, second FIR and charge sheet.
On what ground are you challenging it?
Your Worship, on the ground of similarity, in fact, the charge sheet has been filed in both the cases, and it's copy paste of the first FIR. If I may take your Lordship to the page 131.
131.
Yes.
Yes.
And your Lordship will see middle of the page,
Yes.
3.16, findings in respect of C. Lal Saniba as under. And if I may take your Lordship to the second charge sheet in the second FIR, which is at page 310.
Yes.
Your Lordship, it's ditto, copy and paste of the findings in the first charge sheet. So, my humble submission, Your Lordship, is that since both the FIRs pertain to the same incidents arising out of the same transaction, the law is well clear that the second FIR cannot be registered. It's a copy and paste of the first charge sheet.
FIR is ditto. No.
The charge sheet is ditto. The case made out against the petitioner is the same. Everything
Okay,
is
right.
same. Copy
Right.
paste.
Right, Mr. A.R. Malhotra, learned counsel for the petitioner who submits that that charge sheet number 4/2024 dated 25/6/2024 is exactly the same as the charge sheet number. Charge sheet number? This is again same.
No, 201. Yes. The first charge sheet in the ISOL PS is at page 35.
You're asking for quashing the FIR.
As well as the charge sheet in the second FIR. Because
The second FIR is what? The first FIR, what is the first FIR?
the first FIR is at
Number 3.
page 17. Sorry, page 15.
No. Forget page. Forget
Yes.
the pages.
Yes.
The first FIR is what is the what is the PS case number?
ISOL PS case number 96 of 2024.
How can you said out here 3 of 24?
That is the second FIR.
You said the first information report of CNEO
Yes.
PS case number 3 of 2024. You said the first.
This is the second FIR.
Please come to page 12.
Yes.
Please read number 2.
The first information report of CNEO PS case number 3 of.
That's what I'm saying. So
Yes.
this is the first this is the first FIR.
No, this is the second FIR.
But why have you this is the second
FIR, the
Okay.
first information report.
Okay.
Yes, yes.
Uh-huh. And the first FIR
Is at page 35, ISOL PS case number 96 of 2024, dated 20th of March 2024.
first FIR is dated
20th of March 2024.
2024 and second FIR is dated
25th of June 2024.
and charge sheet in the first FIR is
The charge sheet was submitted on 10th of July 2024,
10 July 24.
and supplementary was also thereafter filed.
Then in the second one,
Second one, charge sheet was filed on 25th of June 2024.
FIR is 25th June.
Yes.
FIR 25th June.
Sorry,
charge sheet
sorry. FIR in the second case is 29th of March 2024.
29 March.
2024.
Okay, right. Heard Mr. A.R. Malhotra, learned counsel for the petitioner who submits that the impugned second FIR dated 29/3/2024 in C and EOPS case, C and EOPS case number 3 of 2024 under should be set aside. Inasmuch as the contents of the charge sheet dated 10/6/2024 pertaining to the first FIR dated 20/03/24 and the charge sheet dated 25/6/2024 pertaining to the second FIR dated 29/3/2024 are the same. Issue notice returnable in 4 weeks. Miss Vani accepts notice. Addition PP accept notice on behalf of the state. Petitioner takes steps for service of notice upon attack. Yeah, for whom?
3.
Mr. Sivaram Chana accept notice on behalf of respondent number 3. Petitioner takes steps for service of notice upon the respondent number 2 by registered post within 3 days. This is the matter after.
There's an interim prayer. The proceedings, the charge sheet has been filed in both the cases. The first case is pending for the Chief Judicial Magistrate. The second case is pending before the Judicial Magistrate First Class number 3. And the contents of the charge sheets are the same. Now,
The interim order, the prayer for interim order will be decided on the next day. List the matter on. Just a second.
Obliged. Item 2.
Just say, don't say will be decided on, just say issue notice on the prayer for interim order. This is the matter. Same here, same thing.
Same, similar order. Item 3.
Item 3, if I may submit, if my learned friends agree, it's a covered case. Earlier, 3 writ petitioners, landowners arising out of the same award, had approached this Honorable Court, and it was registered as WPC 83 of 23 at page 134. And page 134.
Yes.
And Your Worship, this matter was disposed of on 25th of November 2024. Their lands were acquired for the approach road to the Chimpipi Bridge, by a draft award number 1 of 2022. The award was made under the Mizoram Land Acquisition Act 2016. And this Honorable Court had already held that the Central Act will apply, 2013 Act will apply. The state had preferred an appeal, which was dismissed by the Honorable Division Bench. So, this Honorable Court had held that the assessment should be made as per the Central Act of 2013. So, the prayer made in this present writ petition is similar to the prayer made in the PPC 83 of 23, which has already been disposed of.
What is your prayer?
Your Worship, that the award should be assessed in terms
As
of
per the 2013.
Central Act 2013.
At the time of making the award, did you make a challenge to this?
Yes, in fact, Your Worship, it was not required, because if I may take your Lordship to the preliminary notification.
So have you received the compensation?
Yes. If your Lordship,
When did you receive the compensation?
if your Lordship will see the preliminary notification at page 22.
22.
This is the true type copy.
Yes,
Paragraph number 8, Your Worship.
yes.
The notification will not stand in the way of landowners or cause any prejudice with them to make a further claim under the 2013 Act, depending upon the outcome of writ appeal number
Okay,
30. So it was the interest of the petitioners was safeguarded by the state respondents while issuing the preliminary notification.
Okay. So where is your name here? It's not here. In this preliminary notification.
Preliminary notification, Your Worship, only the schedule is given. The names
Yes,
of the
who is appearing for the other side? Yes, so is this a covered matter or not? heard Mr. A.R. Malhotra, learned counsel for the petitioners, who submits that the lands of the petitioners were acquired by the respondents by draft award number 1 of 2022 in terms of the Mizoram bracket land acquisition, comma, rehabilitation and resettlement bracket Act, comma, 2016, hereinafter referred to as the 2016 Act. However, in view of the decision of this court in the judgment and order dated 15/11/2017 in WPC number 20 of 2014 and WPC 30 of 2014, which has been upheld by the division bench in WA number
70 and 71.
70 and 71 of 2018.
18.
The land of the petitioners would now have to be acquired and compensation paid in terms of the right to fair compensation and transparency in land acquisition, comma, rehabilitation and resettlement act, comma, 2013, hereinafter referred to as the 2013 Act. Next one. The petitioner's counsel submits that at the time of issuance of the preliminary notification dated
Page 21.
preliminary notification dated preliminary notification number K12011/34/2012 RFA dated 29/7/2022 issued by the Additional Secretary to the Government of Mizoram, Land Revenue and Settlement Department, comma, the acquisition of the land of the petitioner would depend upon the outcome of WA number 70 of 2018. As this court in WPC 20 of 2014 and WPC 30 of 2014 had held that where is the holding done by the court? Page
That's about page 34 onwards. Page 53 is the operative code.
had held that. What have I said? Had held that the 2013 Act was not applicable to the state of Mizoram and that compensation would have to be paid for acquisition of land as per the 2013 Act.
If I may, I think the sentence, Your Worship said 2013 Act is not applicable. It's
No, I said 2016 Act is not applicable. No? Yes, what did I say last sentence? The 2016 Act. 2016 Act was not applicable in the state of Mizoram, and that acquisition of land would have to be done as per the 2013 Act, and as the same had been upheld by the division bench in WA number 70 and 80
70 and 71 of
70
2008.
and 71 of 2018. Comma. The petitioner's compensation would have to be enhanced or modified in terms of the 2013. Miss
Caroline Kilworth.
Ms. Zairem Sampui, CGC, appearing for the respondents number 1 to 3, and Ms. Caroline Kelung Orpui, appearing for Mrs. Appearing for the response number
4 to 7, my lord.
4 to 7. Fairly submit that this is a covered matter in terms of the preliminary notification dated page 22, dated 29/7/2022, and the judgment and orders passed in the WPC number 20 of 2014, 30 of 2014, and WA numbers 70 and 71 of 2018. The petitioners would have to be paid their compensation amount in terms of the 2013. I have heard the costs for the parties. In view of this court having held in the above writ petitions and writ appeals that compensation for acquisition of land in the state of Mizoram would have to be done in terms of the 2013 Act and not as in terms of the 2016 Act. The respondents are duty bound to pay compensation, to assess and pay compensation to the petitioners in terms of the 2013. Accordingly, the respondent shall assess the amount payable to the petitioners for acquisition of land in terms of the 2013 Act, and after making necessary deductions of the amount already paid to the petitioner, the remaining balance, if any, should be paid to the petitioner. The same should be done within a period of
4 months.
4 months from the date of receipt of a certified copy of the same. These
Okay.
petitions accordingly.
Item 4.
Give me this 2013 Act. Yes, what are you praying for, madam?
My lord, our case is relating to the rehabilitation and resettlement, which has to be done as per the right to fair compensation for offense in land acquisition, rehabilitation and resettlement Act of 2013. Our prayer is for setting aside the impugned notifications and letters, my lord.
Your land was acquired.
Yes, my lord.
When was it acquired?
It was acquired in the year 2020, and compensation for the land as well were given to us around January, February 2021, my lord.
21.
Yes.
And
Our buildings,
you have taken that, and now you have come here for what is your grievance?
our grievance is that, my lord, our buildings have been acquired for the construction of the national highway within the village, which is within the district of Khazol. And our buildings have all been demolished. We have not been paid any settlement or rehabilitation.
You have been paid your compensation.
That is for the land, my lord, and assets. There is another award which has to be given to the landowners or families.
Why haven't you gone in reference?
My lord,
Is
pardon?
there any reference
Yes, my lord.
provision for reference?
Yes, my lord. As per the Right to Fair Compensation Act, Raffler Act of 2013, Schedule 2, at the Act, I am using professional. at second schedule, which deals with the elements of the rehabilitation and resettlement entitlements for all the affected families, both landowners and the families whose livelihood is primarily dependent on the land acquired, in addition to those provided in first schedule. The first schedule deals with the compensation for the land assets, multiplication factor, solatium, interest, etc., my lord.
No, madam.
Yes, my lord.
So you're not happy with the award.
My lord, the thing is that draft award for the rehabilitation resettlement was done by the respondent number 5 and submitted to the respondent numbers 3. Thereafter, impugned letter.
My question is very simple, madam.
Yes.
Are you happy with the award?
There are 2 awards and we have not been given either from the, we have not received.
I have not asked you that. That is not my question.
Yes,
Whether
ma'am.
you have been given, not given, going to be given, never going to be given, that's not the question.
My lord.
My question is, are you happy with the award?
My lord, yes. If it is done as per the act.
If you are happy with the award, then why have you come?
Because, my lord, the award as per the Raffler Act was rescinded, my lord, and a new JICA award was done. A new award was done as per JICA, my lord, which is not as per law. And
Madam, you see, you've got to be, you see, this is a writ court.
yes, my lord.
Only an aggrieved party can come to the writ court.
Yes, my lord, I understand.
If you don't have any problem with the award, if you don't have any grievance with the award, how can you come to the court?
Because, my lord, as per the act which was, the award which was done as per the act was rescinded and no compensation for the rehabilitation was given.
Was
to me
rescinded
today.
when?
If I may have your lordship at attention at page number 106, annexure number 8. This is the impugned notification issued by the respondents, my lord.
Whereas the awards of compensation. Madam, how does this affect you?
Yes, and in pursuant to this impugned notification, another
Madam, when I ask you a
yes,
question,
my lord.
you don't answer it yes and then you continue. You've got to address the question, the
Yes, my
issue.
lord.
It's not like supposing I ask you, what is your age? You know, yes, I'm wearing a very pink dress, beautiful dress. I'm not asking you that. The issue is, this is a notification of 22.
Yes, my lord.
How does this have any bearing to your case?
Because, my lord, as per that notification,
Which notification?
the one that I've just shown you,
22.
yes,
22
subsequent to the notification dated 15 November 2022, another correspondence was issued, which is at page number 108, annexure number 9, my lord.
How does this 15 November 2022 prejudice you?
Because it has stated that entitlement, if I may read, my lord, whereas the awards of the compensation for rehabilitation and resettlement of affected families already submitted for 6 districts along National Highway 54 due to the compulsory land acquisition for widening and shoulder dressing of the said highway could not be accorded sanction by the Ministry of Road Transport and Highways, Government of India and the NHIDCL. And whereas the entitlement matrix of the draft resettlement action plan 2000 approved by the state government of Mizoram shall have to be followed in preparation of the awards for the resettlement of the affected families as resolved in the joint meeting held on 22/8/2022 under the chairmanship of the Honorable Minister Land Revenue and Settlement. And whereas the notification previously issued by November so and so dated 14/10.
Madam,
Yes, ma'am.
your village, where is your village?
It is at Khozol, my lord.
Khazar.
Yes.
Now, this notification
Yes,
deals
madam.
with Highway 54.
Yes, my lord.
Has the Highway 54 gone through your village?
No, my lord, it is national highways. No, my lord, I am bringing you to the page number.
Look, madam, this notification deals with Highway 54, that is Aizawl, Serchhip, Nathial, Longklai, Lunglei, Saiha district. Khazol is not included, madam. How are you affected by this notification? come to page 106, your notification. Look at the the third line.
But my lord, my lord, if I may have
Go
your
ahead.
attention
Yes.
at page 118.
They need to have a standing committee. No, please help her. No problem, no problem. Help her.
My lord, if I may have your attention at page 108, my lord.
Yes.
Last paragraph, my lord.
Yes.
Oh, wait, if I may read from paragraph number 2. I am also directed to request you to convert previously prepared R&R award as per RAFLA 2003-13 for NH into R&R award as per above JICA's guidelines entitlement matrix and furnish directly to NHIDCL on or
Wait. For which national highway?
Yes, 54. I am coming to that, my lord. I am coming to the other districts. On or before 2011-2022 Sunday, promptly for consideration by the NHIDCL or MORTH Government of India by giving copy to the undersigned. Last paragraph, R&R award for national highways other than NH54 may also prepare and send directly to
You see,
NHIDCL.
these are for awards that are going to be made.
Yes, my lord.
Yours is already made and given in 2021.
No, my lord. R&R has not been given to us, my lord. We have not received any amount, any money for that. We have received only for the first schedule, my lord. So based on this, a new award for the resettlement, rehabilitation resettlement was,
We'll take it up again day after tomorrow. You read. We'll see. Read the matter again day after tomorrow.
Admission, item number 5.
My lord, service report is still awaited from the respondent.
My lord, I have not yet received the paragraph's comments. If I may be allowed another 3 weeks time to file my affidavit.
My grievance is very simple, my lord.
Please show me the Land Revenue Act 2013. So you have got a garden pass, right?
Yes, my lord.
In terms of the 2013 Act,
Yes, my lord.
where is the law regarding this pass for the thing?
My lord, my grievance with regard to this case is the non-issuance of the sport verification report, in as much as my corpse has
No,
not been.
your grievance might be there,
Yes, my lord.
but what about the status? What is
Yes.
the what status do you have? What is your right as a what kind of land holding
I
right
will
do you
at
have?
least be entitled to crop damage compensation, my lord. If I am not entitled to land value,
Let
I
us
will-
see. Let us see what the law says. Is there any section on VC pass in the 2016 Act? Or the rules? Under what is the provision for issuance of a VC pass in the 2013 Act?
My lord, with regard to the past, my lord, if there is any dispute, then
No, I'm asking you the law. I don't know. You tell me. Then you have to.
yes, my lord. I agree that village council does not have the authority to issue guardian pass. It has been covered by your lordship judgment. In
No, that is my judgment was old law. As per the new law, 2013 Act, because your VC passes of 2016.
Yes, my lord.
Where is the provision for issuance of a VC pass for agriculture purposes? You see, the rules provide allotment of land for agriculture purposes shall be made either by periodic pata or by land lease for specific tenure for specific purpose.
My lord,
It does not give any power to the
yes, my lord.
village.
Yes, my lord. Since they have given that we have enforced, but however, if I may take a lordship to page 26 of my writ petition, because this village council pass have been mentioned,
Your village council passes of 2000.
my village council pass is 2016. my lord.
So 2002 and 2016 that the Mizoram land revenue laws came into force in 2013.
13. Yes, my lord. If I may, if your lordship allows me to explain, my lord, page 26 of my writ petition, my lord.
Yes.
This is a part of the notification dated 23rd July 2021, and the concerned village is village title. If your lordship may kindly see serial number 2, 3, 4, 6, 7, and 24. These were all village council pass number 56 of 2016, and they were included in the notification. And
Maybe mistake done or a thing done in violation of the law does not give any
yes,
right.
my lord, I'm not trying to claim negative equality, but what I am aggrieved is that these persons were also given for damage compensation. And what I have done is that in the area which was allotted to me, rightly or wrongly, I have done certain amount of crops, and it was all destroyed. And I have submitted a representation to the deputy commissioner and the Kala, my lord, additional deputy commissioner. And in pursuant to my representation, the joint verification notice was issued by the deputy commissioner of Saitwal district, Saitwal. However, even after due verification, the report was not prepared, whether the certain amount of crops that was damaged or not has also not been reflected. So I am at loss here, and I cannot go to the court because my case is kept in abeyance by the state.
No, you see,
That is my only problem. my
you see, the thing is this. Supposing some person who's not connected with the High Court comes and makes a plantation here in our compound, and we chop off the trees and the cash crops that he plants. Are we liable to pay him anything?
That will be illegal entry upon the High Court.
Then your land is government land, not your land.
But my lord, similar other matters, I would still be entitled to court damage compensation. That's all, my lord. And rightly or wrongly, let him dispose. And if he's disposing of my representation,
So
reject.
you are admitting to the fact that you cannot be the owner.
My lord,
We would have to
I
clarify
would
that.
I would not like to admit to anything, but my lord, my only grievance is that let the representation be disposed of, rightly or wrongly, and whether I have locus standi or not will have to be decided in the.
We can decide
Civil
now. We are locus standi, we can decide now. Not difficult. It's here the law book. Give a copy. Please. There's nothing provided. You see this section, this section 37 onwards, chapter 6. Agricultural land cannot be given by the village council.
Yes, my lord.
Even in the 2013 Act.
However, my crops have been damaged. That is the
Okay, so if you admit that you cannot be the owner, then we can direct them to consider that aspect. I'll clarify. I'll clarify it. I'll clarify it.
if the lordship permits.
I'll clarify that issue. Because you see, we cannot go on the shades of grey.
Yes, my lord. Then at least crop damage, my lord. Because from what I've learned from other landowners, village council pass were not given land value, but they were paid for crop damage compensation. So my grievance is that my crops were damaged.
You see, and the early cases, though, they're different. Now, this is your cases of 2016 village council pass.
Yes, sir.
That time the 2013 Act came into force.
Yes, sir.
What if village council can give only for household?
Yes, my lord. What we want at this stage is just for the Kala to dispose of our representation. And my lord, if your lordship permits.
Yes, anything? Who is appearing?
My lord, I will be appearing for Kala. Respondent
Okay.
number 3, however, I have not filed my power and I have not received the copy. However, the office of Kala have received the copy.
So what do you want?
Uh,
What is your submission?
I will be filing my power today during the course of the day. So, my lord, if it
Where is your power? Where is it? It's here. We
yes,
submitted today.
yes,
We
my lord, will
dispose
be,
it off. Let Kala take a decision.
yes, my lord.
They take a decision on his representation. Okay, we can clarify this aspect. We can ask Kala to clarify with regard to this chapter 6 of the Land and Revenue Act.
Yes, my lord.
Okay, right. Heard Mr. Zoram Chanala, counsel for the petition. Also heard Miss Caroline Lumopui, learned Mrs. Learned counsel for verse 1. Miss Lan Sakifana, appears for point number 3. The petitioner's case is that he is the owner of a plot of land covered by Village Council Pass number 214/2016, located at Saichal Village in Saitwal district. The petitioner's grievance is that though a number of similar lands as the petitioners had been acquired, has been included in the notification for acquisition. What for? Where is the notification? Page 13 had been included in the notification dated 23/7/2021 for widening of for which was to no. The petitioner's case is that in terms of the notification dated 23/7/2021, objections were invited from landowners whose lands were going to be affected by the proposal to build bracket widening / 2-lane with paved shoulder bracket 4-laning etc. of a road. In relation to NH 102B from KM 0 to KM 122. The petitioner's counsel submits, next para, that though landowners who are having similar village council pass issued by the village council for agricultural purposes had been given compensation / damages for damage to their crops and trees. The petitioner has been excluded from the said list. So he submits that the petitioner should also be given compensation for the damage caused to his crops and trees on the land covered by Village Council Pass number 214/2016. The petitioner's counsel submits that the petitioner's representation dated 8/11/2024 to the respondent number 3, asking for a spot verification of the land and to award compensation for damages to approximately 70 meters of his land has not been exceeded to by the respondent number 3 till date. he accordingly submits that the respondent number 3 should be directed to dispose of the petitioner's representation dated 8/11/2024. Next, Ms. Caroline Lungoipu, learned counsel for the respondent 1 and 2, and Mrs. Saki Fana, learned counsel for the respondent number 3. Submit that. What do you submit?
My lord, that I will be filing my power today.
Forget that. Not that.
And I have to get instructions from my client.
He is only asking that his representation be considered.
Yes, yes. If ever there is a representation, we will definitely reply, my lord.
Then we will send you reply. So we will dispose of the representation.
My lord, the thing is that I haven't, I'm not aware of the case because I haven't received the copy. That's why.
Or you haven't got material instructions. What?
Yes, my lord.
Yes.
The staff, the Kala didn't personally send me the soft copy. So that's why I have no idea. I have
No, what is the problem if we dispose it off now? Oh, so it will not come. Yeah, have you decided?
no, my lord. If it may be taken up day after tomorrow.
Okay. Submit that they need time to obtain instructions. Accordingly, leave this matter day after tomorrow. Anybody ready for part 2? No. Okay. Okay, so we are planning to open that on Friday.